Hi, my name is Cullen, and I'm a personal injury attorney in Winter Park, Florida. We handle probably more than our fair share of personal injury cases that have to be litigated. In other words, cases where we file a lawsuit on behalf of our clients to protect their legal rights. In many civil cases, motions are frequently filed in order to make things happen in those cases. And I've previously recorded a video talking about motion practice in Florida generally that you can find on our webpage or our YouTube channel if you want more information about motions generally. One of the more frequent motions that we see or file ourselves in personal injury cases are motions to compel. And motions to compel become necessary because of the discovery process. Anytime a lawsuit's filed in a personal injury case, each side is entitled to or has the right to participate in discovery. And discovery has to do with both parties gathering information about the other and trying to figure out what the case is about. So motions to compel are often required if one or the other of the parties is dragging their feet on providing the information that the other party wants. Or maybe they're refusing to offer it altogether, or maybe they're holding back information. So a motion to compel is drafted or filed by one or the other parties. And in a motion to compel, basically you're asking the judge to get involved in the situation and asking the judge to hear why you think you're entitled to the requested information. The other party then gets a chance also to speak their mind and to argue why you shouldn't be entitled to the information that you're seeking. And then a judge, after hearing all of the arguments of counsel and asking questions of his or her own, the judge will then decide whether or not to compel the production of the documents or the production of the information that the parties want. Many times judges rule all in one party's favor or all in the other party's favor, but in a lot of situations the judges give you a little bit of what you've asked for and let the other party hold back a little bit of what they've wanted to hold back. So really you just never know until the motion is ruled upon. So in many of our cases, once a motion to compel has been filed, many times we just get on the phone with our opposing counsel and we see if we can work it out. And most of the time, if we have experienced lawyers involved in the case, we can work it out because we kind of know over experience of time what a judge is likely to order to compelled in terms of information, and we kind of know what judges are likely not to order compelled. And we're all familiar with the case law that surrounds all of these sorts of issues because they've been going on ever since civil lawsuits began. So a lot of us who've done this a long time kind of know what the important issues are, and we can usually work it out with one another. If we're able to work it out with each other, then typically we can do an agreed order and send it to a judge, and the judge will sign it. And once an order is issued in the case, then the parties have to comply with it, or they can decide if they want to take it up on appeal if certain prerequisites are in place. So if you have any questions about a motion to compel or how a motion to compel might be used in a personal injury case, please reach out to us. We'd love to answer questions. All you have to do is call us at 407-254-4901. You can text us at 407-644-4444, or you can even reach us through the Facebook Messenger app.